Mr. Higginson didn't show up. Same here.
Yeah, kind of. Until he broke down. I'd rather hear it with money.
What? What's the last one? I really wasn't yeah. Really much. Yes. I can get my top and it's like easy.
Okay. So this just
Yeah, it's just
Jeremy?
I'm Jeremy.
Robert Higginson.
Nice to meet you.
Nice to meet you.
I saw, I saw that.
So nobody gets this thing started. This is
Please wait. You wait until somebody else talks.
it's good to meet you.
You too.
By the way,
Oh, we got
we do. That's what I said.
the one you just studied. I call it Caughey. It's the fire truck. It's on the outside of the ATV.
Oh, yeah.
It's I gotta tell, I always remind myself, make sure that every day is a weekend. Because I know one of these days I'm gonna say, look, I had to get 31 because it was a weekend. And I got in there and it's
But anyway, listen,
yeah.
let's
Yeah.
be friends.
Yeah.
Hear ye, hear ye. Court of Appeals for the Fourth District. Justice now in session. Pursuant to the law of the God, save the Constitution and this honorable
Please be seated. Welcome to the First Court of Appeals. We have two cases on the docket this afternoon. We'll take them back to back. But first we will hear from case 0124000797CV, City of Houston and Carwin Alexander Flores versus Myrna de la Cruz. Starting with appellant, counsel, please make your announcements.
Robert Higginson for the city of Flores.
Thank you, Mr. Higginson. For appellee.
Good afternoon, Your Honors. Jeremy Maston for the appellee, Myrna de la Cruz.
Thank you very much. And each side will have 20 minutes. Does appellant wish to reserve any time for rebuttal?
I would like to reserve 5 minutes, Your Honor.
Okay, very well. And you have the clock in front of you. When the light turns yellow, that means you have 1 minute left on your time. If the light turns red and you're in the middle of answering a question, please feel free to finish your answer. We have read all of the briefing and the record in this case, and so we don't really need a recitation of the facts. I know that there are some facts that are relevant to the discussion, of course, in this particular case. So if you guys want to dive right into the issues, that would be really helpful to us. Starting with the appellant, please.
May it please the court, I'm Robert Higginson for Houston and Mr. Flores. And the ultimate thing here is that the court should...
Did we start the time?
Oh, it's not going.
Thank you, Justice.
I'll start over. May it please the court, I'm Robert Higginson here representing Houston and Mr. Flores. The court should reverse on immunity grounds based on limitations as to both Houston and Flores, but first I'll address the court's questions that prompted the letter briefs, and that is whether 51.014A8 authorizes Mr. Flores' appeal, and whether limitations is an assertion of immunity within the meaning of 51.014A5, such that 51.014A5 is an alternative ground for Mr. Flores' appeal. Both of those would authorize Mr. Flores' appeal, as I stated in my supplemental letter brief, and I'll just go over that reasoning again and what those sections of the statute say. You might have, I realize you might have both of those statute sections in front of you. I'll just refer to them quickly here. They say a person may appeal from an interlocutory order of a district court, county court at law, statutory probate court, a county court, or a business court that, skipping down to paragraph 5, denies a motion for summary judgment based on an assertion of immunity by an individual who is an officer or employee of the state or political subdivision of the state, skipping down to paragraph 8, or grants or denies a plea to the jurisdiction by a governmental unit, as that term is defined in section 101.001. Now, to take the first one of those, 51.014A5, and the court noted in your request for supplemental briefing that that wasn't mentioned as the basis for appellate jurisdiction and notice of interlocutory appeal. The rules of appellate procedure don't require a statement of the legal grounds for the interlocutory appeal. Excuse me for my little cough thing. And so the first thing to note about this is that 5 is referring to a summary judgment, not to a 91A, but this court has already pretty much decided that a few years ago in Hung v. Davis, where following the Texas Supreme Court's opinion in Austin State Hospital versus Graham, this court concluded that even though that appeal, Hung v. Davis, arose like this one from a 91A motion and not a summary judgment motion, that this court has appellate jurisdiction over that. The Supreme Court has said multiple times it doesn't matter when a excuse me.
Yeah, please go ahead.
That it doesn't matter what procedural mechanism the government is using. Now, this is different from a private party defendant.
Well, is there any question here as to whether he was acting in the scope of his employment? Is there any dispute on that?
I'm basing this solely on the pleadings.
Right.
All right, and so...
For that purpose, no, there's no dispute.
I'm
they
having
frame
a
it.
little bit of trouble hearing you. And
As the allegations frame it, there's
They-
no question that he's acting in official capacity, correct?
I see none. I see no basis for it being in an individual capacity. He alleges that Mr. Flores was in the scope of his employment. This is essential for a plaintiff to plead it that way, to be able to bring the city in as the employer. And so if that weren't the case, and he were suing Mr. Flores individually, that would be a different matter. So this is...
But you agree 100% that despite the different arguments for how we get jurisdiction, that this is only raised as a 91A. The only issue before us is the 91A question, if we decide we have jurisdiction.
I want to understand your question, Justice Caughey, and that the only issue before you is the 91A question about whether you have appellate jurisdiction over this?
No, I'm sorry. If we agree with you that we have jurisdiction,
Okay.
you're not asking us to construe this as something other, as a plea to the jurisdiction or something else, or summary judgment. You're only arguing that your 91A should have been granted.
Yes.
Okay.
I'm not wanting you to, like in federal courts, they sometimes will convert a 12B6 motion, which is kind of a federal analog of this and a basis for this, into a summary judgment. That's not what we're asking you to do.
Okay, so you agree in 91A then that we can't look at any facts, correct?
Well, you look at the pleadings.
Right.
And you're allowed to look at the pleadings of the defendant
Right.
as well. Now, and this is a lovely point to consider what the evidence, or what the effect of the evidence in this record might be. Because we aren't relying on evidence so much as what Cruz has put in the record and relied on in terms, first of all.
What is an allegation that we can consider that's specific as to the date of filing? Not the file stamp, but an allegation. Is there one?
There is not well, there are two answers to that. First of all, there is not an allegation of when it was filed.
Why is that not conclusive?
Because you can, all right, because the...
Let me ask you a better question. Why is that not dispositive of your Rule 91A, where we're limited to looking at the allegations in the pleadings? And there is no allegation concerning the time of filing.
Okay. If we're going to look at strictly the allegations in the petition and nothing else that the plaintiff filed to try to correct his filing date, because in there's all this information about when he was late in serving. That's all contained in the plaintiff's filing.
But aren't we required to, we are in fact limited to just the allegations. We can't look at everything in the record, right? Based on the Rule 91A standard.
Well, you can take judicial notice, I believe, of the clerk's office stamp on there.
Can we take judicial notice of the filing system?
I believe you can do that. I believe you can take judicial notice. Well, and then since you've got this filing system, we're getting into something about where counsel has suggested, look, I really filed it on this last day, and it shows that I filed it 3 days later instead of Friday and Monday. And he's basing that on what the stamp on the file stamp says. And so the file stamp says it was 3 days late. So he's filed something else that's not part of the pleadings. I mean, it's a motion. It's called an affidavit of correction, but then at the end asks for some relief and refers to Cruz as move on. And so either this court can consider those additional items of evidence, attached evidence that the plaintiff put in the record for purposes of determining diligence, and that's what this is really about here. Diligence in service.
How could diligence be a 91A question? What's your best case for enabling us to look?
Excuse me. All right. City of Houston v. Mecca is a strong one. Hold on a second. Okay. I would have to give you a post-submission brief to answer that question.
Yeah, Mecca's on
if you'll
your,
allow.
in your reply brief, right? It's City of Houston Mecca's Spring Court 2024.
Yes.
Yeah, that's in your reply brief.
Yes.
So we could look at that.
Yeah, sure.
But
And,
how, separate the service point.
Okay.
If we're looking at just timeliness,
all right.
if there's a fact question as to when it was filed, because there's nothing in the actual pleading that alleges when it was filed, why is that proper for 91A?
Okay, well, yeah, I think that's when you say things like that's a good question, it sounds like a filler, a delay while you're trying to think of stuff. I can't help but say that's a good question because there are things about 91A that aren't yet firmly established from the Texas Supreme Court. And so we are using it in the City of Houston to try to get the Supreme Court to clarify certain things about 91A so that we know what to do going forward, and so that plaintiffs know how to plead and what facts they had better have before they file their lawsuit. And so there is a difficulty, I'll admit, there's a difficulty here in this, because a plaintiff is not likely to ever plead, you know, I'm filing this late. And so that would suggest that maybe you never use a 91A for this. Not that it wouldn't be an acceptable vehicle, but that it just won't ever really fit for the reason I just said. The plaintiff's not going to say, hey, you know, I'm filing this after the limitations period has expired. Now, if the court affirms, and this goes back to the court, to the Supreme, the one that's down there, the district court, county court law in this case, the next step is we just make the same argument in a different procedural vehicle. We file a motion for summary judgment. All the evidence is there. The same evidence you're seeing now.
Well, that's why I started whether you're trying to convert this to a
No.
summary judgment or plea to the jurisdiction, or no, and your answer is no.
No, and it's still no. But we'll be doing that if there's not a way that this court sees that 91A is a proper vehicle for this situation.
There is a lot of unclarity, I think you're right, with respect to Rule 91A in the context of plea to the jurisdiction. And I do hope the Supreme Court will give us some clarity on that point. But there's one point that seems pretty undisputed, and that is that we have to look at the allegations in the pleadings, and we've had a lot of case law developing that very standard, and we have to construe the allegations as true. So this is very analogous, for example, for 12b-6, what you referenced before. I mean, that's really the essence of where Rule 91 originated from.
Right.
We didn't have a motion to dismiss in state procedures, so Rule 91A. But it seems to me that you're really asking us to go beyond the allegations and to really consider evidence to make a determination as to whether the statute of limitations had passed on February 5th when the stamp reflects the actual filing was made, or whether there was due diligence. It seems like we have to consider some evidence, or the trial court would have had to consider that. And so there's a tension between what the city's asking us to do here and what the law says we're limited to do on review, which is looking just at the allegations and the pleadings. And some evidence, but it's evidence as defined in the rules, and that would not include us taking judicial notice of everything in the record. So help us reconcile the well-established law that says we're limited in that respect on our standard of review.
Well, I'm not sure that I yet have a resolution for that. The problem that we are in, and I'll concede this also, maybe we should have used an MSJ to begin with instead of a 91A. But here's where we are, and we have all of this record here that establishes, you know, the service 5.5 months after limitations expired is lack of diligence as a matter of law in light of the various cases that I cited in my three briefs actually. Well, the two briefs, not the letter brief. And since I'm really not, and can't believe, ask you to convert this like you could in federal court to a different mechanism and consider the evidence, I'm thinking that, or at least not convert it to an MSJ, because there are some procedural requirements in terms of timing for that. But it's a plea to the jurisdiction in a form. It's one of the forms of plea to the jurisdiction. And so far, case law says you can't consider evidence, and yet here, if we have, all right, what is a governmental entity to do if you get, as we did here, a petition that on the face of it, the file stamp says, this is after limitations expired? Go straight to MSJ? Because maybe
You
there's
could
some
file a plea
explanation.
to the jurisdiction, right? In which case you could consider evidence.
Well, and yes, that's a possibility, sure. That might have been the better way to do it.
But like, let's consider this 91A route. Are you familiar with any instance in which, let's say there was no real question here. Let's say the file stamp was 6 months after the statute of limitations expired. Can you point us to any court that's looked at that in the 91A context?
No, I have not, and I think that it might be that what we're doing with 91A in the city of Houston is perhaps a little bit ahead, if I may put it that way, of a lot of other municipalities. We have so many lawsuits filed against us.
Yeah, if I remember right, there's a car crash, what is it, every 2 hours, or do you know the number better?
Well, that sounds right, Justice Gunn. It's an incredible number. You know, the city this size and the number of government employees there are, you know, with over 4,000 police, similar number of firefighters, and then just other departments that have vehicles, and there are collisions.
What about in the 12B6 context? Are there analogous cases that are really on point in that context?
Well, in the 12B6 you can attach some evidence in some situations. If a plaintiff, for example, like here, if a plaintiff refers to some evidence and relies on it in a petition, then you can rely on that.
I know you're done, but let me ask one more question.
Oh.
Let's say that we could take judicial notice, just setting aside all the questions. Say we could take judicial notice of the filing system, and let's say that this was a hypothetical case where the system showed 100% they did file on the last day, but it got bounced, but they actually filed, it just wasn't recognized by the court on the last day. Would your position be on a 91A issue that we could write an opinion saying you lose outright because, on this argument, just this argument, because we could take judicial notice that in fact the filing was on time?
Yes.
Why?
Because it's, all right, on the face of it, this is what you'd have to go by that says this is the date it was filed within the limitations period. Now then you get into a whole separate issue about diligence. That's not the question you're asking.
Right, exactly.
Sure, on the date, the basis for our assertion is that clerk stamp. You know, that it's filed too late.
But the clerk stamp's not dispositive of that question, is it? What law says it's dispositive?
I don't have one that says that, yeah. And perhaps it should not be. I want this to be clear.
Thank you, yes, this is very helpful.
Yeah, I want this to be clear too.
Thank you.
Thank you for your argument, appreciate it. We're ready to hear from the appellee.
Thank you, Your Honor. May I please the court? So I want to begin by answering one of the questions that y'all asked a minute ago. Are there any cases that dismissed a case on limitations in the 91A context? And I feel honor bound to point out that the city did identify 2 cases in their reply brief. In one case, the petition was filed 2 years after limitations, and in the other one, it was filed 1 year after. But more importantly, for the context of 91A, in both of those cases, the plaintiff didn't dispute the file stamp. So I don't think this is a situation where we get far enough past and now we can do it.
That's why I asked the question, if it was 6 months later, would everybody agree then we could dismiss, and we could reverse the 91A?
I still think it doesn't fit into 91A territory because there are all kinds of things that can go wrong with the file stamp. I mean, I know it's not a physical stamp anymore, but back when it was a physical stamp, the year number could get wrong, you know, and then now it looks like it was filed 5 years after. Or maybe the petition has a typo with when the accident occurred and says it happened, you know, in this case, says it happened in September of 21 instead of February of 22. You know, I mean, I think that I hesitate to say there's no amount of time that could ever be taken judicially notice of, but it's hard for me to imagine, particularly.
If we're considering just the allegations, what allegations can you point to that raise a fact issue about whether you were on time?
Well, the statute of limitations is an affirmative defense. There's nothing that requires the plaintiff to
To
plead
do anything, right.
that they filed it on time. So maybe going forward, plaintiffs should put in there, I filed this on time. I don't think that's best practice, but on this record, there's nothing in there that says it was filed on time in the petition. Another question that Mr. Higgison asked was, what is the city supposed to do when they get one of these petitions that's got an obviously bad file stamp? I have actually run into this more than once in my career, and what often happens is that the defense counsel calls up the plaintiff's counsel and says, it looks like you filed late. Is there an explanation? And what I've done in my practice is if I have an explanation, I give it, and then sometimes they say, all right, then I'm not going to file that motion I was going to file. And sometimes they say, prove it to the court, and they file their motion anyway. But that is certainly an option, and as the court said, they could file a plea to the jurisdiction. The other thing that I wanted to address from his argument is the question about the city of Houston versus Mecca. And what that case dealt with is the idea that we're not disputing, which is that limitations is part of the jurisdictional question in TTLA claims. And so I know he brought that case up, and so I just wanted to clarify what that case was
Would
about.
you agree that, is your position that we could take judicial notice of the filing system or anything to that effect?
I don't think you can, because as I understand it, judicial notice is limited to either undisputed facts or undisputable facts. And the Supreme Court in Biffle, there's also a case out of El Paso that I cited in my response, and there's case law going back over 100 years that says that the file stamp is prima facie evidence of when it was filed, but it's not conclusive.
Right, but would the filing system itself be conclusive if we could actually see the attempt at filing that was timely?
I think that still falls into evidence, and I don't think that you can take evidence on it.
So how would you get there, essentially, is the point, not on a 91A?
You can file a motion for summary judgment. Rule 166A says that defendants can file a traditional motion for summary judgment at any time.
Right.
And that's probably coming. I mean, right? That's going to be the next thing you have. So what do you think is going to happen on remand? That hasn't happened yet.
I think you're probably correct, but this is not my only case. And I'm a big fan of statutes being interpreted how they're written. In my letter brief, I indicated that I personally don't think Hung versus David was decided correctly, because I think 91A motions and motions for summary judgment are different. And if the legislature wanted to treat them the same, they could put them both in the statute. But I understand the policies behind it. And that lines up with what I'm saying here. 91A says trial courts cannot consider any evidence. And if we start getting case law that says, sometimes you can, sometimes, then it's going to be very hard for future litigants to figure out which way they need to go. What
about a harmless error analysis to say, okay, yeah, it shouldn't have mattered, but we can see how the story's going to end? I mean, assume the error. So now fight the harm part, because there are cases that say, oh, the harmless error rule applies to everything.
Well, then as he indicated in his argument, from their perspective, this is a diligence case, and he says, as a matter of law, 5.5 months is too late. That's not diligent. Maybe it is, maybe it's not, but that's an issue that he's going to have to prove in the trial court, and that's something that's going to be developed in the record on remand, whether or not. I can imagine a scenario where, it takes 5.5 months to get somebody, and that is acting diligently. I don't know if the record's going to show that on remand, but that's certainly going to be an issue on remand. And so I think that's where the harm comes in, because if the question is, did they file it on time? Well, then we run into the issue of the file stamp as evidence. And if the question is, did they serve us on time? Well, then we run into the question of how do you prove diligence? And neither of those are going to be in the petition. And both of those I expect will be contested.
You said Hung was wrongly decided. Can you talk about that a little bit?
It's a very simple argument. Hung versus Davis says that in 51.014A5, where the statute says motion for summary judgment, we decide that those three words can also mean motion to dismiss. And I understand the principle behind it. I'm not sure that I disagree with the policy, except that, you know, we're a nation of laws, and litigants have to take their guidance from how the laws are written. There's some case law going all the way back to 1924, where the Supreme Court of the United States has said that if the words of the statute are clear, the remedy, this was a federal case, the remedy is with Congress, not with the courts. And so maybe 91A should fit within 51.014A5, but those words aren't there. And so that's kind of my position on that. That case, by the way, is Chung Fook versus White, 264 U.S. 443. And so I don't want to belabor the issues, but from our perspective, this is a relatively simple case. In order to prove limitations, you have to prove when the claim accrued and when the lawsuit was filed. And in a TTLA case, you have to prove diligence in service to prove jurisdiction. And while you can show accrual from the allegations in the petition, you can't show filing date. And so you got to go outside the petition to get that. 91A doesn't let you do that, and so we think that the case should be reversed. And like I said, the argument from our perspective is relatively simple. I still have about 11 minutes. I'm willing to answer any questions, but from our perspective, it's pretty straightforward.
Any questions?
What if there were a record of the hearing below and your side admitted away the case on the record, but it's not in a pleading? Would that count? Would it matter? I'm thinking what could count in addition to evidence? Stipulations, other admissions, and so on. Just wondering where those all fit.
I think then you would run into a situation where you might have, I don't want to call it a judicial admission because I think that gets into evidence areas, but in the two cases that they cited in their reply, the plaintiff just didn't contest. So they could go to the hearing and say, you caught us, we filed too late.
Fair enough.
And how is that clear in the allegations anyway in those cases?
I read 91A6 as a grounds for objection, and you can always waive objections. And so if in those two cases, I haven't gone back and looked at the record in those cases, but I assume that, well, we know that they didn't object to it because there were no objections mentioned.
Any more questions? Thank you for your argument. We appreciate it.
Right.
Ready for a rebuttal?
Thank you.
I have to thank counsel for reading my reply brief better than I did my reviewing. Yes, there are two cases that I cited there where 91As were granted on limitations grounds, and one of them, the one from Beaumont, says in a footnote that Walmart's, it's Webby Walmart stores, page 2 of my reply brief. Walmart answered that Webb's claims were barred by limitations, which of course we did in this case as well for Flores and the city. Walmart timely filed a motion to dismiss the case as a baseless claim, asserting that Webb's suit had no basis in law or fact, citing Rule 91A. The trial court conducted a hearing on Walmart's motion and granted it, and then the appeal, and then we went to the Beaumont Court of Appeals. This is a 2022 pet denied case. The footnote said, Walmart's 91A motion to dismiss does not specifically reference the statute of limitations. But Walmart did discuss the matter at the December 11, 2020 hearing on that motion, indicating that the limitations issue precluded Webb's claim from having any basis in law as contemplated by the cited rule. There's no reference there to any evidence coming in. So there was something that was at play there, and it's just not really clear. And so this is a part of how 91A case law is developing. If you just agree with me and decide it's narrowly on diligence, you could avoid all of this stuff. But I know that's not what you're here for.
I mean, I'd be open to a harmless error argument if you could establish that conclusively.
I appreciate that, obviously, because it serves our position more, it serves our side more, because we are going to be ending up back up. I think here's what I foresee. We go back, we have another mechanism, go over all this evidence. Trial court's likely, in my opinion, to deny it again, or just suppose that happens. We come back up here, possibly in front of this panel, and maybe not even that far out, maybe a few months from now. Maybe this panel's not sitting together, but you reconvene because you already know this case. And then we have this same evidence that we're talking about here, without an explanation for the 5-month delay. Lack of diligence has been shown as a matter of law for as few as 36 days, when there's not a good explanation, and it's after limitations expired. Some people would say, and this is just to be fair, Justice Gunn, some people would say, that's why you play the game. I like your way better here.
I hear you.
I don't know if it fits. Honestly, I don't know if you can do that. I like it. If you're open to it, that's great. If all three of you are, then it's done, or if two of you are. I want 91A to be developed well, so we all know what we're doing. But I also think, and something that I have to respond directly to, is this idea that statute of limitations is an affirmative defense. It's different when you're suing the government. Sure, it's an affirmative defense, but not here. The government doesn't have to show that it has immunity, ever.
So what is your position? Is your position then that they have to essentially have something in the pleading that shows they were timely?
In terms of the timing?
Yes.
Well, we haven't gotten to that quite yet. I haven't really formulated something about that. We're kind of going along here and trying to figure out, okay, look, what is it that they really need to plead, specifically the facts under Supreme Court case law, particularly Rattray and Dolan and a few others that I've cited in here, Texas Tech v. Martinez and some others. What's the specific thing they have to do to show, if it's true, a basis in fact and in law? And if they don't, if they leave this out, then they haven't pled grounds that, if true, would get them over the immunity. And so they haven't
given
satisfied
that
Sir?
So given the background law on immunity, you would want us to hold that basically any plaintiff suing the government in their petition has to say this is timely filed.
I would like to see that. When I think about that, I think, wow, am I reaching too far here? But I like that. I mean, what they do have to plead now, at least under Twyman opinion from your sister court, is they've got to plead that their notice was timely within the 90-day city ordinance, and not just that they satisfied all preconditions, and not just that they met the notice requirements under the TCCA, which is 6 months. And as it gets more and more focused, it's going to become a much more efficient rule or mechanism for protecting governmental immunity, protecting the public funds.
Can you address whether
Sure.
his argument that Hung was wrongly decided and the implications of that?
Are you going to defend our honor? Somebody's honor?
I'll defend all three of your honors, Your Honors. Sure, but I didn't quite understand. Justice Caughey, I think I'm going deaf. I am sorry that I'm asking you to repeat yourself so many times.
Oh, don't worry.
You asked how I would do something before.
Your friend said
Justice Gunn
Hung
that
was
thing.
wrongly decided.
If it's wrongly decided?
Can you address that, please?
Oh, if you do what Justice Gunn says?
No,
No.
just is it wrong?
Do you think Hung is wrong, or do you think it's
Hung.
right?
All right. I have to get my money back on my hearing aids. Hung is right.
Has anybody else said it's right, wrong?
I'm sympathetic to the fact that we have to follow the text, and it says summary judgment. It doesn't say 91A motion to dismiss. So what do we do with that?
You follow the Supreme Court's handling of that, saying that it doesn't matter if it's a summary judgment or a traditional plea. or a 91A, that all of them are challenges to the jurisdiction. And so, and the one that I was quoting earlier, where they said it doesn't matter which one it is. You could say, I think it was the Austin State Hospital case. But yes, there are some differences between them, but they're not relevant to this situation. There are differences like who gets fees. Yeah, that's not an issue here. If I could pretend that's a continuation of my answer. Counsel said something about we didn't object. We have no obligation as a government to object. You can't waive immunity on your own. It's either in the statute as interpreted by the Supreme Court or it's not. That's it.
Thank you to both parties for your argument. This case is submitted, and we'll give the council opportunity to occupy the tables here, council's tables, for our next argument.
Thank you, Ryan.
Yes, you are excused. Thank you so much.
Now you're free to stay. All right, it's up to you. You can go watch online. Mason, yeah, we got it.
Thank you.
If you need to petition for a name change, we can grant it right now. We've got her name misspelled on the plate.
Yeah.
Oh. I don't know if you'll have jurisdiction for that.
You may be right.
Very well. Okay, we're calling our second case on the docket this afternoon. We will now hear case 01240087CV, Lillies versus TGS-NOPEC Geophysical Company. Starting with appellant, counsel, please make your announcements.
Scott Persky for the appellant.
For the appellee.
Jessica Mason, Taylor Appling for Appling.
Okay. And only you will be arguing, Ms. Mason? Okay. Thank you. Appellant, how long do you wish to reserve for rebuttal?
5 minutes is fine.
And you already heard the drill before. Yellow light means you have 1 minute left of your time. Red means stop, of course. If you're in the middle of answering a question, you feel free to finish your answer. And we are very familiar, again, with the facts, and we've read the briefs and studied the record, the jury charge as well here. So if you can just dive right into the issues, that would be really helpful.
Sure. Let me start off with, when we tried this case with Ms. Mason, this is not a typical, we believe this case is not a typical case for employment law. It's got a long history that goes back to essentially this date of March 3rd, 2017 and June 30th, 2017. So my client, who's here today, she filed these protected activities with the HR department. She noticed pay disparity between males in her department, and so she filed these protected activities. These original protected activities in June, the one on March 3rd, the one on June 30th, culminated and had her boss, this individual by the name of Gajwada, then what we would indicate would be fabricating these performance issues. And there were 3 performance issues that she undertook. There was 3 of them that culminated essentially around December of that year of 2017. Then her lawyer at the time, an individual by the name of David Kwan, sent a letter to the HR department, which essentially sort of stopped the process for her from being terminated. But then after that complaint, which really wasn't responded to, but it was determined then that they could proceed with their then termination, okay? What's unique about this case, which I pointed out in the briefing, is that my client basically admitted on that last 3rd assignment that she could not complete it because of the fact that it dealt with something that was outside of her job description, outside of her experience, and that was done on purpose and essentially having her set up to fail, okay? So when I came and I tried this case, and I'm looking at the jury charge, and I'm looking at the pattern jury charge instructions, and I'm going at them and I'm looking at them, I'm relying upon that Reeves falsity instruction. It's critical to my case because of the somewhat long, drawn-out fact pattern that this case presents, going all the way back to that protected activity on March 3rd and June 30th.
Mr.
Go ahead.
Yeah.
I understand your argument, so the falsity argument. The brief spent a lot of time on question 1 and 3, which are of course the key questions. But if you're looking at the corresponding question, for example, question number 2 in the charge, why does that not then cover the argument that you're making? The question that was presented to the jury was, did Lily engage in poor job performance for which TGS would have legitimately terminated her employment solely on that basis?
You're talking about which question?
Question number 2.
Okay, question number 2. Let me pull it up.
So 1 is the 2 is what you get to if you answer yes for 1. So 1 says, did TGS terminate Lily's employment because she complained of gender discrimination? Right. And then 2 says, if you answered yes to 1, then answer, did Lily engage in poor job performance for which TGS could have legitimately terminated her employment solely on that basis?
Right, question 2, which wasn't answered.
Right.
So what's the question, I'm sorry?
So, yeah, so what I'm understanding your question is because there is the allegation that the legitimate business reason that was advanced by TGS was a falsity. Your point is that you wanted the permissive pretext instruction to be given to be able to flesh that out for the jury.
Correct.
My
on question
question
1.
is why, if you read retaliation question number 1 in conjunction with question number 2, and gender discrimination question number 3 in conjunction with question number 4, why are those not bookend questions that would have covered and allowed your ability to make that argument to the jury?
Because that argument wasn't fleshed out in question 1. It lacked the Reeves instruction.
But let's go to the Reeves instruction.
Yeah.
So, okay, if the instruction had been given, then before us, we would unquestionably have the question of was it proper, the correct statement of law, all those issues. But in a case like this where it's not given, would you agree that the trial court retains broad discretion on whether to give instructions or not? And what about, for instance, the Johnson case that looked at facts pretty similar to these and said, well, you have discretion to not give it, especially here where counsel you had the opportunity to argue to the jury. Essentially, they never directly say why we're firing. You got to make arguments of the same sort.
The Johnson case came out in 2018. The Texas pattern jury charges, Justice Gunn should know because he was on the charge committee, it indicates that they added the Reeves instruction to the pattern jury charge in 2018, I believe.
Is your position that the pattern jury charge is law that we have to follow, or what's your position on that?
My position is that it's very important for me as a lawyer to be able to rely on the Texas pattern jury charge as an authoritative source to establish what needs to be in those things. Is it the law? No. I mean, of course, we all know it's not the law. But the issue that what I get into is that you have to look at the facts of this case.
But what law says that an instruction is mandatory just because it's in the pattern jury charge?
You know there isn't any.
So then how does it become, because the question here is essentially, was it mandatory? Did it have to be given, Or did the trial court have some discretion, or even if it's an abuse of discretion not to give it, was it not reversible error here to not give it on this record, right?
Right.
That's the question.
Because that's when you have to look at the facts of this case, and that's why I started my argument today looking at the facts of this case. Because it's very difficult for a jury to go back and to understand, when you're in these employment law cases, this is not a situation where the employer makes up something that's completely wrong and false, which does happen. It happens all the time. This is not that kind of situation. This is a much more discrete issue about, and I think you would crouch it in terms of setup to fail, the fact that you have to go back and you have to look, and you have to look at these 3 assignments that she was under. And you have to look at the facts, you have to you have to go into it, and you have to determine whether or not there's any evidence to indicate whether or not these assignments were made, according to Ms. Mason, to help her improve and make her a better employee, or on our side, their falsity in their setup. The boss knows what she's capable of, knows what she can do, and there's purposely giving her the assignment in order for her to fail, because he's trying to get rid of her, and he's trying to get rid of her with a paper trail. Let me finish. And so in those cases, the facts are very difficult. And so that's where I would say, yes, that's where I need the Reeves instruction, and that's where I
Well,
need
but
it.
needing doesn't mean you're entitled to it. And I think that's the question that we're getting to it. Even when the facts may warrant it, is it an abuse of discretion for the trial court judge to refuse to give the instruction? Because that's what we have to answer in this case.
Yep.
Does the evidence warrant it? Maybe. Does the party want it? But is the law says that this is a mandatory instruction that the trial court must give in every case in which there's evidence of pretext. And there's cases from the federal court in here going which way. So we're trying to get your position on that.
Sure.
Is your position that this is a mandatory instruction that has to be given when there is evidence of pretext in the case?
No, that is not my position. My position is that in this case, as I've indicated, in this case, that it is mandatory because of the facts, but I'm not asking for this court from a blanket rule to say that this Reeves instruction must be given in every case. As I stated, there are a lot of cases where the employer can just get up and lie, and then there's no evidence of anything, and then obviously in those situations, the jury can determine whether or not the company witness is lying on their own, right? You don't need that instruction.
So why is it mandatory here?
What's that?
Why is it mandatory here?
Because of what I'm saying about the facts of the case.
What if you set aside this record? What if you had the opportunity to argue everything you might have wanted to argue to the jury? Would it still be mandatory?
Yes, because the pattern jury charges, because it fits with the facts of the case, it's a correct statement of law, and it should be in there.
Let me pause you on correct statement of law. Beaumont said an instruction just like this in 2023 was not a correct statement of the law. Correct?
Eastland?
Sorry, Eastland in 2023 said that an instruction like this was not a correct statement of the law. Correct? There's a split in Texas on that now. Would you agree with that?
I don't know, what was the name of the Eastland
It's
case?
Barron Aviation Services
Oh,
versus
Kitchen?
Yes.
Oh, okay. Yeah, Kitchen's an interesting case. That case, I would say that there was an interesting issue in that case, but if you looked at it, I would say again, the court analyzed the facts of that case, and they didn't go so far as to saying this is an incorrect statement of law.
Well, is it okay to
They had questions about it. They indicated that they were concerned. The concern here, and I think the real concern is that addressed in the Kitchen case, it has to say that they believe that it's shifting the burden onto the defendant to then show that something is true or not true. And if you looked at that case, and if you looked at the comments, what I believe the real argument is that they're trying to say that if you put a Reeves instruction in, that it's forcing the jury to then say that if you prove falsity, you automatically can prove discrimination, okay? So I think that's the concern, and it's a valid concern. And I read it and I looked at it, but the problem with it is that you can't discount, you can't look at the Reeves instruction in isolation. You have to look, like in this case, you have to look at the predicate question. You have to look at question number 1.
But wouldn't this instruction go in question number 1? So this is exactly
Yes.
where I was
Yep.
going. So if question number 1, you had to say yes, and then after you say yes, then there was some follow-up question that asked this, then I would agree with you that there's not an issue, but doesn't this instruction in question 1 allow the inference without also requiring a finding of discrimination at all?
No, because it goes in question 1.
But question
So-
1's the one asking about discrimination.
Exactly. So you have to remember the predicate question. You can't look at the Reeves instruction in isolation. You have to look at where it fits in question 1. And so the central question that's being asked for the jury is, did TGS terminate Lely's employment because she complained of gender discrimination? That's the predicate question. The only thing that the Reeves instruction does, like we have it all the time in the Texas pattern jury charge, we have PJC 100-8, we have circumstantial evidence, jurors may infer the existence of facts from proof of other facts. We have PJC 100-11, a Fifth Amendment privilege, adverse inferences may be considered by a witness not answering a question and invoking the Fifth Amendment, and then in the same wording, but you are not required to infer by such refusal that the answers would have been adverse to the party's interests. There's another one. There's one about spoliation, PJC 100-14. Again, same inferences can be
So
remained.
help me understand this. Let's take a hypothetical scenario where a jury finds no evidence of discrimination based on sex, but there is an instruction like this, and the jury does not believe, let's say that the company says, I'm terminating you because you did bad work. And the record is crystal clear, they're actually terminating you because you showed up late every day, and they don't like when you're late. But they said it's because you did bad work, and the record's clear in this hypothetical. So let's say in that hypothetical, the jury has no evidence of discrimination based on gender, but disbelieves the reason for termination. Would your proposed instruction allow then an inference of sex discrimination because they disbelieve the reason of poor work performance when the real reason was you're late?
Absolutely not, because you still have to ask the predicate question. The question asked whether or not if there was gender discrimination. They're still responsible for answering that, and so therefore if there was no evidence of gender discrimination, they wouldn't even get to the Reeves instruction. It's not even important. They would answer no.
I have a question.
Yes, sir.
Does the record tell us why the judge didn't go down this road a la the pattern jury charge?
I don't believe so.
Frequently, the judges, when they're not certain, will say, look, it's in the book, that's what I'm going to do. I'm just curious if you can cast any light on that.
I can go, Ms. Mason might be able to shed some light on that more than I can. I don't recall the problem that you get into, and I'd have to go look in the record, and I can if you'd like me to. But I don't remember if we had a charge conference where there was some discussion about it, and then my recollection is we showed up the next day, and then I submitted my thing, and he said refused.
Right.
But I don't know if Judge Miller, I can't recall off the top of my head. I can go look.
No. I can look at the record.
Can I ask,
That's
I know we're over time, but can I ask just very quickly,
Sure.
can you tell me why Johnson and Caughey are not on point? Caughey's from San Antonio in 2015, and Johnson, you mentioned 2018 from our sister court.
Well, Johnson, there was an article by Mr. John Griffin, who was on the PDC committee, and he explains that Johnson was not decided, as I've indicated, at the time that 2018 edition of the Texas Pattern jury charge was so the Reeves instruction wasn't in there
So that's your distinction, is those cases came before.
on Johnson, and then what was the other one?
Caughey, it's from Collie, it's from San Antonio in 2015, it's very similar to Johnson.
I'm not sure about the Caughey case,
Okay.
I'm sorry.
But it's also before.
Yeah, it was before, and so the thing about it is what's I think is important as a practitioner who's a trial lawyer that's down in court, that if I feel like that if I structure my case on this and I rely upon the Texas pattern jury charge, I believe that and if the evidence supports it, and the standards vary, it's not much to show that as long as the facts fit the case and it's a correct statement of law, then it should be in there. And so that's one, and because of this case, because of the long period of time, I relied upon that to show falsity. And I think it was a difficult case, and it was a hard case for that. It wasn't an easy case to try this case because I don't have any smoking gun type evidence. I don't have, so that it's very difficult. And so in that instance, as long as that that instruction is in there, and there's some discussion about, well, it shifts the burden onto the defendant, but I think the critical language is that it states infer. And the language of the text is, as long as it states infer, and it is not, it's permissive, it's not mandatory. It says we may infer that, and we do that all the time. And we have those kind of things and those kind of inferences. Employment law is a unique area of civil law because there are lots of different type of inferences that come up. And there are inferences that are favorable for one side, and then there's inferences that are also favorable for the defense. Like we have the same actor inference. Like,
But you cannot point me to
What's
any, but you cannot point us to any case law that would say that, because I'm sympathetic to your argument, it's in the pattern jury charge, you look at the pattern jury charge, you structure your case on it, and then trial court says no, what do you do with that? But you can't point us to any case that says that the fact that it's in the pattern jury charge has legal significance.
well, it has legal significance as long as the facts of the case fit that.
Right, but then we come back to, but the trial court has a broad discretion. So the question is, did they have discretion or not?
Right, did they have broad
that's the
discretion?
question.
And
Right.
so in this case, I would say, that's why, like, if you were gonna write an opinion on this, I would want to see where you're analyzing the facts. And you're saying that in this case, and what I'm saying about, because of the pattern of what happened, because the fact that the client said, well, I can't perform that assignment, that GPU assignment that she was fired for, was given to her because she couldn't do it. It was way over her head. And then it was given to a male, this individual by the name of David, was given after her, and he couldn't perform it either. Then in those kind of situations, the Reeves instruction becomes critical to be able to explain to the jury and to have it in there.
Mr. Porsche, I want to give you an opportunity, Ms. Mason, we'll grant you additional time because we've been talking about the instruction. If we agree with you that it was an abuse of discretion not to include the instruction, can you walk us very briefly as to why that probably resulted in the rendition of an improper judgment? Because here, I understand your point, but looking at the record during closing arguments, of course, the whole theory of the case was that the reason for termination was a fabrication, right? That it was manufactured or fabricated by the employer, and that they had basically set up the plaintiff here for purposes of retaliation or gender discrimination. In essence, you were able to argue to the jury that there was pretext and that there was falsity involved here, and there is a jury instruction, at least with respect to the ability of the jury to reach certain inferences from circumstantial evidence. So if we're having to analyze this second bucket that we're going to have to get to, right? If there was an abuse of discretion, did that probably result in the rendition of an improper judgment? Why then can we not say, well, given everything we have to look at, the pleadings, the closings, the evidence, the argument, there was really no improper judgment rendered here?
Because it's very important for those for those instructions, those Reeves instructions, to come out of the mouth of the judge. I can make the argument, Ms. Mason can make the argument, but in this case, because those facts fit that, and because you have a very delicate situation of my client basically saying, I cannot perform that GPU assignment, the jury has to be instructed to look beyond that and to determine whether or not this was actually meant for her to be a better performer, or whether or not it was more of a pretext to get her fired. So in this case, and that's what I'm asking, in this case, I see that it's very important and critical to have that in there and to have the Reeves instruction. And I'm not asking for some blanket ruling that indicating that it's mandatory in all cases, because they have to be analyzed based on the facts of the particular case. And we have a pattern of discrimination going back over a year prior to the date that she was fired. Therefore, in order to make the jury understand and to make the jury know that with her admission about what she testified to on the stand, that yes, you still can consider that testimony and go behind it and to determine whether or not the assignment in the first place was valid and whether or not it had a legitimate purpose to it. Does that make sense?
Yes, thank you.
Okay.
Any further questions? Thank you, Mr. Persker. We appreciate your argument.
You're welcome.
And so that's 8 additional minutes for you, Ms. Mason.
You may use them, but you are not required to.
I will keep that in mind. May it please the court. I would like to start by addressing the question of, whether the instruction is mandatory, when it should and should not be given. Our position here today is not that the instruction should never be given, but the cases are abundantly clear that the court has the discretion, after sitting through trial, hearing all the evidence, to determine what instructions are going to help the jury best.
Can I just ask you before we
Please.
get started, do you believe the instruction is proper as written?
I do not.
And why?
I do not, because I think there's a few reasons. First, it is not an accurate statement of the law. It is our position, as I think best articulated in the Barron case, which I do want to point out. In the Barron case, the court overruled, the trial court issued the instruction, the appellate court out of Eastland found error. The employee appealed that further on this particular issue to the Texas Supreme Court, who declined the petition for review.
Right, but we don't know why.
We don't know why.
Right.
But it certainly is suggested that it was not clearly erroneous, since it is such an issue of great import.
So is your position, is your dispute with the way that it's written, not that a permissive pretext instruction could be given under the right circumstances when it's worded correctly?
I think there's actually a number of reasons why it's so deeply flawed that it really should not be given.
Ever?
Candidly, no. That's not the issue
Can you
in this case.
Can you walk us through?
Absolutely. So the first reason is that it's not an accurate statement of the law because, as you were discussing previously, it does shift the weight. It suggests to the jury that mere disbelief of the employer's proffered reason is sufficient to say it must be discrimination.
So
And
I
even-
asked that question about, are you
Yes.
divorcing the two concepts? And there's burden shifting involved too, but just are you divorcing the concepts? That what if there's no evidence of discrimination based on sex at all, but there's definitely evidence of pretext? What happens? And your friend's answer was that it's subsumed in question 1, so that solves the problem. Can you explain why it does or does not?
It does, and if I'm not tracking your question, please redirect me. I think I am. I think it does because there's additional instructions, like Justice Rivas-Molloy noted. The jury is already instructed that they are the sole arbiter of credibility. The jury is already instructed that they can consider circumstantial evidence and that they can draw inferences from that.
Right,
The
so that's
issue
a
that's
different
missed-
question. Sorry, go ahead.
Sorry.
Continue.
The issue that's missed is what to do with that inference. The Reeves instruction it erroneously states that that inference is enough to find intentional discrimination, but not just intentional discrimination. So even beyond your example of, well, they were late or they did bad work, which is it? Is it age? Is it national origin discrimination? Is it disability? These are all issues that did arise in our trial. The plaintiff put on evidence that she was a different national origin, that she was a different age, that she had suffered from these medical conditions. And so the jury cannot find sex discrimination based on an inference merely of falsehood. They have to figure out what is it an inference, what is it substituting for?
But this instruction, the proposed one here, doesn't say that the jury has to find it, right? It just says it can.
Correct. It says it's permitted to find unlawful discrimination.
Well, what about the argument that you still have to look at the predicate question, right? It's the permissive pretext instruction would be cabined within question 1, which says the TGS terminate Lily's employment because she complained of gender discrimination.
Yes, I think it still remains flawed for, again, a few different reasons. One is it's confusing to the jury. Number one, there's already these inference instructions, and it's also an improper comment on the weight of the evidence. The reason is they're already instructed on inference, they're already instructed on credibility. By placing an additional instruction of this particular circumstantial evidence and this particular inference within these questions suggests to the jury, who are not lawyers in most cases, that why is circumstantial evidence different here than in the rest of the charge? Why are they not telling me about direct evidence? I feel like I heard direct evidence, and we did hear direct evidence in our case. So why is the judge, who's so smart, not instructing me on the direct evidence?
So help me understand this. If the instruction is not a correct statement of the law, then I definitely follow why it would be an impermissible comment, because you're telling the jury to put extra weight on this, and that's not correct. If you assume for these purposes that it is a correct statement in the law, is it still an impermissible comment on the state of the evidence, and why?
Yes, because the jury remains the only party who can decide who is telling the truth. And once you decide it is true, it is not true, you still have to decide what the rest of the evidence telling me.
But
What
Ms.
is it
Mason,
not
this
true?
is not the only type of situation or context in which juries are instructed on inferences. We've seen some that in the employment context, but outside the employment context, instructions often and can instruct the jury on inferences. Why are we treating this particular instruction different than we would in other contexts by saying that it's an impermissible comment on the weight of the evidence?
Certainly, and I think that one way to look at that issue is to look where this inference arose from. This is really, it is most often applied in summary judgment cases, not in true trial cases. The courts that have evaluated this really closely, for example, in the Fifth Circuit case in Ratliff, on which Ms. Lee relies heavily, every single case that is cited by the Ratliff court is a summary judgment or a directed verdict case, because the inference goes a very far way to say, wait a minute, that's not true, there must be something else here, there's definitely a fact issue. It helps identify a fact issue. It does not, however, help a jury resolve the fact issue, because if they disbelieve the employer, the difference here is, and it's the purpose of the inference, as I think Ms. Lee briefed in her opening brief, it is very difficult to come by direct evidence in employment cases. Other cases may or not be the same. So it's buttressed in any given case by the facts that are presented to the jury.
But the federal law, which is far more developed on this issue than a state court for obvious reasons, has not reached this conclusion that it's an impermissible comment on the weight of the evidence. While there's a split of authority as to whether the instruction must be given or not, no circuit has said that this is an incorrect statement of the law or that it's an improper comment on the weight of the evidence. So we would be, in essence, be breaking, as you will, apart from very well-developed federal law on employment by stating that it's either an improper comment on the weight of the evidence or that the law is incorrectly stated in the instruction. So what is the good argument as to why we should depart from this very well-established discrimination law from our fellow federal courts?
And as I mentioned when I opened, we're not actually suggesting, even though it's my personal legal opinion that it is erroneous, we're not suggesting that it's never appropriate and that there could not be some cases in which the facts and case as presented to the jury do support it. But this case is not that case.
Help us understand, so the other side's argument is that, yes, there's Johnson, yes, there's Caughey, but now this is enshrined in the Texas pattern jury charge. Does that matter? Why or why not? And what do we do with that?
I don't think the fact that it's in the PJC is instructive. I don't think it's a mandatory instruction. And I know the committee works very hard, it's very important, and we all rely on it heavily, but it is not law. And to your point, there's no case that has ever said it is law. It is a guideline. It is a place to start. And in fact, the Barron case, the Barron aviation case, came out while we were in trial. And to answer your question, Justice Gunn, there was an informal charge conference. You will not find this in the record.
Yeah, I was wondering.
But there was extensive discussion on this case as well as some other cases, including the Apache case, which I cannot remember the citation for that one. We didn't rely on it in our brief because it was more of a dicta issue. But there are a number of cases where there has never, let me answer it this way. There has never been a case that has found reversible error, at least that we've been able to identify, based on the refusal to give the instruction.
Well, Ratliff.
Well, Ratliff
in the Fifth Circuit.
Yes,
right?
Your Honor.
But then Canada.
And then Canada, and so there are some federal cases, to be clear. I was referring to state cases. There are some federal cases. Canada dismantles Ratliff.
Well, they don't have the authority
Right.
to undermine that as a later panel. So
Certainly.
Ratliff is Fifth Circuit law.
Absolutely.
And it is the underpinning for a lot of the pattern jury charge developments since 2018. And El Paso says it's a correct statement of law. I mean, we were having this discussion. You're not bound by El Paso, we're not bound by it, but they flat out said it. I mean, plaintiff has the El Paso court saying it's a correct statement of law.
Yes, there are certainly cases that do say it's correct, it should be used, and that have affirmed complaints about the instruction being issued. But I think that's why it's so important to look at this from the abuse of discretion standard. The judge is in the courtroom listening to the evidence right along with the jury and can determine whether or not there is a factual basis to support the instruction.
How? What does the trial look like with that? Because this raises to me an issue of administrability, of a yardstick that the judge can apply. And I'm struggling to know where that line is. Maybe we just have to stay out of it and say, Judge, you can do anything. But if we're going to get into it, help me, how do I draw that line? Because appellant said, I don't want a per se rule. Appellant says, I want it on my facts. So talk me through how the judge is supposed to make that decision.
Certainly. At the first step, is there a scintilla of evidence to establish pretext that would even support the inference? I would submit to the court that there is not in this case. And if I could shift to the facts, it bleeds into the factual sufficiency, but it's hard to divorce those in this issue.
It is.
There is not a scintilla of evidence to support issuing the instruction here because the facts as developed at trial were far more robust and clear than the facts presented in the briefs. Take, for example, the basis of the pretext is the sham PIP, performance improvement plan, where she was set up to fail.
Right.
But that's not what the testimony or the evidence at trial. TGS provided 3 different witnesses, her manager, her manager's manager, and the HR person, who all testified what was in her skill set and what was not. But more to the point, Ms. Lee testified that each of these items, each of these tasks, very specifically, were within her skill set. Ms. Lee admitted that her resume, which is an exhibit that was presented to the jury, highlighted 2 of these 3 skills that she complains that she did not have. And the third one, she had articulated that she was capable of doing. In fact, when she got the assignment for the third project that she contends here is a sham, the assignment was issued to her saying, this draws on your very specific experience doing this type of work. She testified herself to the jury that she did have all of these skills. So that is one example of how a judge could determine that that conflicting testimony, her own conflicting testimony, is maybe not a scintilla of the evidence.
Wait, no, I don't see how conflicting testimony can't be a scintilla. It seems to me you're setting up a test that's so easy for the other side to me, I'm not sure you want to go there.
Right.
If it's conflicting, the judge is going to have to say, I'm sorry, Ms. Mason, I got to give it.
I think what I'm trying to articulate is that it really wasn't conflicting.
Okay.
She said, I don't have this skill set. When that was explored further, I've never done this work before. When that was explored further, the reality is I had not done this work at TGS before. And that is why it's not really a conflict. I misspoke.
No, it's fine.
It's more of a clarification that says there is no doubt.
It's fine. I mean, what I'm seeing is a very important legal question that we don't have an answer from the state Supreme Court to resolve. We have El Paso with one view, we have Eastland with a very different view, we have a pattern jury charge that's not binding, but the next round of comments, and when the 26th volume comes out, it's going to have to say, here are two cases that point different ways, and then whatever this court does and whatever another court does, there may be other things in the pipeline. I mean, I'm seeing something very significant. Plaintiff says, I have Ratliff in the federal courts, I have Reeves, I have the PJC, and we need a test that's going to work for all cases. So it's not a question, it's just, it's letting both of you know how I'm seeing a very significant question emerge.
And it's a fair question, and perhaps the solution is not jettisoning the permissive pretext inference altogether, but rather rewording it so that it simply clarifies how the circumstantial evidence may be considered without replacing the standard of proof. It should not, and I think this language does, erroneously shift or relieve the plaintiff of the burden, showing not just that it's untruthful, not just that it's pretext for discrimination, but it's pretext for the specific type of discrimination I'm suing for today.
Like a pretext plus or something?
Exactly, precisely.
Well, but the case law said pretext plus is wrong. So here's the predicament, right? You can't say too little, you can't say too much. So where is the middle ground? And I think courts have struggled with that.
And I think it's the lawyer's job to help the courts with that, because I think you called out a very important fact, is that this is really complex and it's really hard. And that's why it is the lawyer's job to inform the jury of how to work with the instructions that they are given in the charge, how to answer the questions that they are asked.
Okay, let's come back to what you said earlier when we were talking about the different ways the trial court could have refused the instruction. The first is if there's no evidence. Assume for a second that there is some evidence, even if it's not enough to raise a reversible issue, there's some evidence. Is this an issue of abuse of discretion? Is this instead an issue of, if there is an abuse of discretion, whether there was reversible error anyway? Looking at the Gunn case out of the Texas Supreme Court, they kind of blur the lines. They first talk about abuse of discretion, and then they have this, well, if there's an abuse of discretion, there's no reversible error. And is your position there's no abuse of discretion, and even if there was, there's no reversible error? Can you walk us through why, assuming there is a scintilla of evidence?
Yes. Our position is that there's no error, but even if there was, it did not result in the rendition of an improper verdict.
Okay, and walk us through why. Is it because the trial court has broad discretion, but what does that mean?
Yes, so it means two things, one from the fact and evidence side and one from the argument side. From the facts and the evidence, in this case, there is overwhelming weight And in fact, it is something of a circular argument, and there's a number of circular arguments in this issue that's before you, is that she's arguing that the evidence is so overwhelming and so clear that the unanimous jury verdict that was reached in 45 minutes has to be disregarded. But she's also saying, except I need an inference, because the evidence is not that clear. So I think that
But in the abuse of discretion standard, when the courts talk about it, they say courts have discretion to not give an instruction, even if it's a correct statement of the law, even if it's proper. So what does that mean? How do we determine when is it ever an abuse of discretion? I guess if it's mandatory. So how do we determine if it's mandatory?
Well, I don't think it ever is mandatory, and I think you need to look at the charge as a whole. If the jury is correctly instructed on how to consider circumstantial evidence, on how to draw an inference, and that they're allowed to draw and then, more importantly, apply an inference, and that they're properly instructed that they're entitled to judge the credibility and can find falsity to be impactful, then I think it simply becomes applying the charge as a whole to the facts of the case, which is what the jury is sent back to do.
Okay, and then what about the point that here counsel had an opportunity to make a lot of arguments to the jury, but their position is that's different than a judge offering an instruction. I know Johnson talked a lot about the fact that counsel got to make arguments to the jury. Help us understand your position on that.
Certainly, and I think that argument, and I hear Justice Rivas-Molloy, but I think that suggests that there is a greater weight to a judicial instruction than legal argument, and that's part of why this is so important. As the lawyers in the case, it's our job to tell the jury, based on the facts that we've all presented and we've all heard, how to connect those dots. And so it almost relieves if the only reason a jury finds an answer is because the words came from the judge instead of the lawyers, I think that's indicative that there is a commentary on the weight of the evidence. Because if they're correctly instructed on how to analyze it and they hear how that can play out, jurors they're smart, they're good at this, that's why the system works. So they're empowered to assess the credibility and to draw those inferences. If the judge is telling them how to apply those inferences, instead of merely that they're permitted to draw them and consider them, if the judge is telling them how to apply those inferences, I do think that's a comment on the weight.
Can you point us to some other examples where an instruction's in the pattern jury charge and the court says the trial court had discretion not to give it anyway?
Nothing is coming immediately to mind. I'm going to consider that for my next few minutes, and I will try to.
Circumstantial evidence instruction is one.
Right.
You could give it or not give it.
Right.
100 years ago, we had a statutory device called certification. We could take an issue and send it on the Von lanes up to Austin without deciding the case and just say, here it is, this is interesting and it deserves your answer right now. And they would do it. That was repealed with the 1941 rules, and we haven't had that. If we had it, I would be tempted to send it to Austin, because I think it's extremely important and we need an answer.
I agree, and this is one of those that the Texas Labor Code does not answer this for us.
And the problem is if the answer comes in that wasn't an abuse of discretion or reversible error question, then you don't even get, as you said, to the ultimate issue of, is this proper anyway? Exactly.
And I think it goes to the second part of the question that you asked previously. I don't think that it resulted in the rendition of an improper judgment on these facts. It goes primarily to credibility. The documents, the contemporaneous documents at the time, all very consistent as they reflect the acts and statements of the employer. The only evidence that seemed to change over time or change from the testimony to the documents were from Ms. Lee.
Can you give me a fact pattern, just a hypothetical, where it would be, assume that this is proper, I understand your position, it's not, but assume it is. Can you give me a fact pattern where it would be an abuse of discretion to not give the instruction?
Yes. Okay, so presuming, like you said, that the instruction is correct, I think where there is no real scintilla of evidence to credit the employer's proffered reason.
But that comes back to my question then. I mean, what if there's no evidence that the reason was you're doing a bad job on your job, but all of the evidence was that you're late? Would the instruction be, you're saying the instruction, it would be an abuse of discretion to not give the instruction there?
I think it could be. I don't think it would be, but I think it could be. If the court were to find that and again, I'm hesitant to say it would be, because this is actually from Barron Aviation. The employer's proffered reason, it was a moving target. It was just changing over time. And the court still found, and that's why the court, well, according to the appellate court, that's why, one of the reasons why the court issued the pretext instruction. And the appellate court still found it to be improper.
Why can the answer not be as simply if it's evidence of pretext, they get the instruction? I mean, not every employment case is going to have a pretext. Oftentimes the employee will say, that's exactly right, I did that, but that's not the real reason I was terminated. I was terminated because of my race, gender, insert the blank. So why can the rule not be, if there's a scintilla of evidence raised that there's pretext, the plaintiffs get the instruction in this case? To the plaintiff's case here, there was evidence that this was fabricated and this was pretext. Should they get the instruction here?
I think you said it spot on. I think that's right. If there's
No, she's
evidence,
saying that you should have had to give the instruction here.
but I disagree that there was any
Right.
evidence.
You
Yeah, she's
disagree on
disagreeing
this
with
record.
that.
On this, right.
But
Okay,
she would
well-
agree that that would be basically, if there's evidence of pretext, they get the inference, the instruction there. But when there is no evidence to support pretext, then they don't get the instruction.
Precisely. I know we use the gatekeeper
Right,
concept and
correct.
expert
Wait,
stuff,
hold
but
on.
it's really appropriate here. They're the
Pause, I
gatekeeper.
want to understand this, because I thought that was very different than I understand your argument to be. So my understanding was you were saying the trial court had discretion and there would be no reversible error here because of the counsel's argument to the jury and everything else. What my colleague is saying is that if there's any evidence, it's an abuse of discretion to not give the instruction. End of story, you lose. So you're agreeing that if we find any evidence of pretext at all, you lose?
No, and that was inartful on my part. I think it's the converse. I think that it would not be an abuse of discretion to give the instruction where there is evidence of pretext.
But you're not saying you have to give it.
Yes, correct.
In Flores, the state, the text dot, if I recall right, said you shouldn't be giving it at all, regardless of the evidence. Don't give it. This is not a proper instruction. And you don't have to agree with what their brief said, but that's my memory of the merits brief in Flores.
Yes, in Flores, they found that the instruction was not improper, and they noted specifically that when the discrimination case has been fully tried on the merits, the reviewing court doesn't engage in the burden shifting analysis. They only look at whether it's, whether the evidence is legally sufficient. And they suggest that that's the court's role to say, is there legally sufficient evidence for me to give this instruction?
That's the appellate decision in Flores. And then the state took that up and said, we don't agree with that at all. This is a bad instruction in all cases. And we don't have an answer from the Supreme Court.
Correct, exactly. And we've never had an answer on this from the Supreme Court, because a lot of the cases talk about tennies, but it's not about the instruction in that case. It's just about how the motivating factor is applied. So we really are at a loss, and I certainly don't think, to the extent we are going to make new law about what instruction should be mandatory in an employment case, I don't think these facts support issuing that instruction, because in this case, there is no evidence of pretext. The pretext, there is no evidence of pretext because her entire argument is premised on this concept that she was given work, number one, that she did not agree to do, that she said was outside of her, what they call a performance development plan, your goals for the next year. But again, that is, the evidence showed that that's up to the employer to decide what the business needs entail. She said it's a sham because they gave her work that she was not asked to do previously at TGS, but the evidence was uncontradicted that she not only had the skill set that was necessary, but that TGS knew she had the necessary skills before it was assigned. And third, she contends that the work was impossible to achieve and that no one else could do it either. But that is also not correct. I'm running just about out of time. I want to make sure there's any other questions. I'm happy to go a little deeper into the IT assignments.
Any other questions? Thank you. We appreciate your argument. We're ready for rebuttal.
Sure.
We've just heard there was no evidence of pretext. Do you want to take a swing at that?
Oh, well, I disagree with that.
All right.
A couple of things you can do, and I appreciate the analysis, and I think you understand my argument exactly. A couple of things, if you want to draw a line, a couple of things you could refer to, as I've already indicated. You have cases where you're set up to fail type cases. You have long drawn out fact patterns, and in this case, the client testified, and it's in my brief where she said when she was terminated for that goal 6, that GPU assignment, the last one is she got it a 3. She says, so the testimony said I was terminated because I did not complete goal 6. I agree with that testimony, but I don't think I should really be harshly punished to be terminated and put on a PIP for that GPU project, okay? So she has that, there is that testimony. You can call it instances where the issue of falsity of motivation, you could use terms like unclear or murky. That comes from the line of cases on employment law where motives are often more covert than overt. You can talk about manufactured evidence of poor performance. PIPs or reassignments are used not to improve, but to justify termination.
Can you tell me a case where there is an abuse of discretion in not giving an instruction, ideally when in the pattern jury charge, but whether it is or not, and what made it an abuse of discretion? Something that
I don't have a case off the top of my head, but I can get you one and I can go look at it, because there's lots of cases. If you like me to do that, I'd be happy to do that. I don't have one off the top of my head, but I can certainly oblige.
Okay.
Okay.
That's what I'm trying to understand, is where this line is. If we think there is some evidence, if we agree with you that there is something, there's more than a scintilla of evidence, but the trial court has this broad discretion, how do we reconcile that? How do we decide when it's an abuse of discretion and when it's within their vast discretion? And if you could help, if you could, very short.
Sure. And
less than one page.
That's what I'm trying to say. So you need the instruction when the issue of falsity is murky or difficult, where it's difficult.
But are you asking us to make law that says that, or are you basing it on law that exists? Are you asking us to be the first court to say that?
Well, that's a good question, and I know I can look. I just pulled up some terms and looked at it while y'all were talking, because you asked for some sort of line
Yes.
about where you draw.
Yes.
And I can go back and look at that if you'd like. I'm just giving you my opinion as to what I would say what you could do if you decided when you write this opinion, and some of the guidance that you could say. You need it when you need it, right? And so you would need it in situations like this case, when you have this kind of murky paper trail, long fact pattern, client testifies she can't do the assignment. It's those set up to fail type cases, and there's lots of them. We see them a lot in employment law. On the other end of the spectrum, you have cases where it's clear they're lying, and in those kind of situations, you don't need the Reeves instruction. It's clear. The jury can look at it and determine.
Well,
what
but
the
why,
witness-
why would that be any different? If it's clear they're lying, you still don't know why they're lying, like my hypothetical.
Well, there may not be a paper trail. There could be nothing. There could be just completely like manufactured, complete lie. There could be something like, well, you have a situation where, well, a client was late on a certain day, and you get the video evidence, and it says, no, she wasn't. I mean, there's like clear smoking gun evidence that it was manufactured, and you know what it was. You don't need a Reeves instruction in that case. But in one like this one, when you have this long paper trail of facts, that's when you need it. That's when it's important to be able to do. And that's what I'm advocating, and that's what I've tried to point out in my briefing. A couple of other things, and I can go look at it, and if you want, I can submit a letter brief. You know, the thing about it is that I don't know if Ms. Mason misspoke, or she said that the instruction said find, and it doesn't say that. The instruction says infer. And so she used the word find in the instruction. I don't know if she misspoke or not, but that's the argument. The argument from Kitchen is that it says that you have to find it, but that's not what's in the language. The language says infer. You can infer it or not. It's permissive, and that's not find. And that's what I think is fundamentally wrong with the Kitchen analysis. The Kitchen analysis tries to say that it's a mandatory, if you find falsity, then you have to say she was discriminated against. Or I think it was a man in that case, but, or my client's a she, but you have to link the two together, but that's not what it says. That the PCGs wouldn't have put that in there to put the word find. It says may, and it makes it permissive. They ignore the text of the actual instructions when the Kitchen court makes that argument, and I don't see how you get there. About the issue about the summary judgment cases, that's an issue that was brought up in that Fifth Circuit opinion, though, the woman, K. Yeah, in that case, you know, they're talking about, well, Reeves is a summary judgment context case. It's talking about the prima facie elements. The prima facie elements are always, whether the jury's instructed it or not, the prima facie elements are still there. There's always what's the last of the three prima facie elements has to do with causation. Causation is the ultimate issue before this court. You can't say that the prima facie elements somehow mysteriously disappear. Our pattern jury charges don't provide the prima facie elements, but actually they're in the Fifth Circuit ones, there actually are. They're like listed out there. And so I don't think that just because, oh, we're not going to follow Reeves because that has to do with a summary judgment or directed verdict case, it's not, that doesn't make sense to me. And I don't think there's any authority to say that instruction is an incorrect statement of law. I believe it's very valid. It wouldn't be in the PJCs. Justice Gunn wouldn't be doing his job if that was in there. Okay. All right, thank you very much. You'll have any more questions?
No, thank you both for your excellent argument. We appreciate it. This case is now submitted, and we are now adjourned.
Thank you.
All right.
And there are several hotels close to the Supreme Court within walking distance, or you can take a taxi if you stay down by the river.